sharing with us today. I yield back.
Gentleman is back. The chair recognizes himself. Mr. Michel, if the government's going to go get information from banks, and understand what happened in this particular situation and in other situations, the government goes to the bank and says, I want the name of the customer who's making purchases in a certain date time, and I want the name of the customer who may have bought a firearm at any time. If they're going to do that, do you think they need to get a warrant first?
Do I think they should?
Yes.
Well, yes.
Mr. Tedesco, do you think they need to get a warrant to do that?
Yes.
Mr. Knight?
Yes.
Mr. Peterson?
Yes.
Mr. Fanone, do you think they need to get a warrant?
I apologize. Sorry. Could you repeat the question?
Government goes to a bank and says, I want the name of the customer who made purchases on these specific dates and may have bought a firearm at any time. Should there be a warrant requirement before the bank has to be compelled by the government to give that information? Should there be a warrant requirement first?
I mean, in my experience, I always sought voluntary compliance. It's less paperwork. That being said, if I was unable to...
Wait. Voluntary compliance?
Correct.
How's it voluntary? This is the third party. The bank's giving it.
No, if I go to the bank and request certain information regarding an investigation that I'm participating in...
I'm just saying in a fundamental sense, do you think there should be a warrant requirement before some financial institution hands over the name of the customer based on certain purchases they may have made?
The issue of government access to bank records without a warrant has become one of the most pressing concerns regarding personal privacy and constitutional rights in the digital age. At the center of this issue is the question of whether the government can or should be allowed to obtain sensitive financial information, like customer names, dates of purchases, and records of firearm-related transactions directly from banks without first going through the judicial system to secure a warrant. The Fourth Amendment to the U.S. Constitution guarantees citizens protection against unreasonable searches and seizures, which traditionally requires law enforcement to show probable cause and obtain approval from a judge before accessing private information. However, the increasing tendency of government agencies to bypass this process by directly approaching banks has raised serious red flags among legal experts, lawmakers, and privacy advocates. In the recent congressional discussion, it was revealed that this kind of data collection has been taking place with little or no oversight. Officials admitted that in many cases, rather than seeking a warrant, law enforcement agents simply request the information from financial institutions and hope for what they call voluntary compliance. This term may sound harmless, but it essentially means banks are handing over data without being legally compelled by a judge. The data often includes information such as whether a person made a purchase on a specific date, what items were bought, and whether any of those items include firearms. The mere possibility of a person having bought a firearm is sometimes enough to trigger government interest, even when no crime has been committed. This practice is deeply problematic because it undermines the checks and balances meant to protect individuals from government overreach. The requirement of a warrant is not a bureaucratic hurdle meant to slow down justice. It's a safeguard that ensures law enforcement can't intrude on private lives without strong justification. Without that requirement, there's a danger that financial data could be used to profile individuals, build surveillance databases, or intimidate people who haven't broken any laws. Worse, this information could be used selectively or politically, targeting individuals or groups based on their associations, beliefs, or behaviors rather than any credible suspicion of wrongdoing. Furthermore, the current environment of rapid technological advancement has made accessing personal information easier than ever before. With a few keystrokes, vast troves of data, once locked away in paper files, are now instantly available. If law enforcement can obtain that information without judicial oversight, then the potential for abuse grows exponentially. In this context, requiring a warrant isn't just a legal formality. It becomes the last line of defense for personal privacy. The implications of continuing this warrantless data collection are profound. Without reform, it could establish a dangerous precedent where financial institutions serve as silent informants for the government, betraying the trust of their customers and weakening the very principles of due process and personal liberty. Protecting financial privacy through strict warrant requirements is not just a legal necessity. It's a moral obligation in a free society.
So in a general sense?
Yes.
You think there should be?
Yes.
That's great, because your colleagues don't think so. Now, let me go to this. Do you think, Mr. Michel, that if it can't do a warrant, do you think there should be at least a notification? So should at least the bank say, hey, Mr. Smith, the FBI just asked me for all your purchases on a certain date, and they want to know if you've ever bought a gun. Do you think that the bank should at least tell their customer who they're supposed to serve? Do you think they should at least be compelled to tell them that?
Yes.
Mr. Tedesco?
Yes.
Mr. Knight?
Yes, with reasonable exceptions for an ongoing criminal case.
Fair enough. Mr. Peterson?
They should get a warrant.
Let's get a warrant. Back to the first thing. Mr. Falone?
Again, with exceptions for criminal investigations.
We got agreement on the panel. The first time we've had that this morning. Dr. Peterson, I want you to talk about the debanking issue we saw so much of, and how that was, particularly I guess with the truckers, and how that's, because I see it coming. I see it coming here, and it frightens me. I want you to
The emergence of FBI liaison reports that request banks to monitor customer behavior is a troubling development in the expanding landscape of domestic surveillance. These reports, while not legally binding, serve as strong suggestions to financial institutions to keep an eye on activities that the government deems potentially suspicious or threatening. What's particularly concerning is the vague and broad language used in these reports. They mention monitoring customers based on interests in firearm purchases, attitudes toward immigration policies, or even dissatisfaction with COVID-19 related mandates. While none of these actions are illegal, the fact that such lawful behaviors are being flagged as risks creates an environment where individuals can be surveilled for nothing more than expressing political views or making certain personal choices. These reports represent a subtle but powerful form of pressure. They don't explicitly require banks to act, but they create an expectation that doing so is part of their civic duty or compliance with broader government priorities. This form of passive enforcement allows the government to extend its reach without going through formal legal channels like subpoenas or warrants. In many cases, banks may err on the side of cooperation, fearing future scrutiny or consequences if they do not comply. This undermines the checks and balances intended to prevent abuse of power, and instead sets the stage for a financial surveillance system that operates in the shadows. The implications of these reports go far beyond banking. They normalize the idea that citizens can be profiled based on legal behavior. For instance, someone who buys a gun, travels frequently, or donates to politically active groups could be flagged not because they've committed a crime, but because their behavior fits a pattern that the government has arbitrarily associated with risk. This is a dangerous evolution of the surveillance state, moving from evidence-based investigations to preemptive suspicion. The damage isn't just theoretical. When banks act on these reports, they can begin tracking or even restricting a customer's activity without the customer's knowledge. Over time, such data could be shared with law enforcement agencies or stored in databases used for broader surveillance initiatives. The person affected may never be informed, never have a chance to contest the suspicion, and never even realize that their personal financial behavior has become a part of a government watch list. That's a fundamental violation of due process and the right to be presumed innocent. Furthermore, these liaison reports often include recommendations that blur the line between security and political ideology, including COVID-19 skepticism or immigration concerns as red flags, effectively labels certain political beliefs as potential threats. This can lead to targeting individuals not based on what they do, but based on what they believe. In a democracy, that's a very dangerous precedent. To preserve the integrity of financial freedom and civil rights, there must be transparent limits on how and when banks cooperate with government surveillance efforts. Every citizen has the right to make lawful choices without fear of being secretly profiled. Without those protections, the fabric of democratic society begins to erode, quietly,
the liaison
invisibly,
information
and irreversibly.
report from the FBI to the bank saying possibly include firearm legislation, the easing of immigration status, new limits on public land, and discontent with renewed measures to mitigate the spread of COVID-19. So the very issue that these truckers were debanked in Canada is the very thing the government is saying to banks, we need to look at this as well. That single issue. That is, again, what frightens me so much. And frankly, when you're getting this information, if you're going to get it, why you should be compelled to get the warrant before you go get it. Mr. Knight, jump right in.
I want to clarify one part of my answer to the second question about notification.
Yep.
The Right to Financial Privacy Act, I think, does a good job of this, where notification can be delayed, but the government has to go to a court and get permission to delay. And I think if we're going,
You shift the burden.
And
The burden's where it should be on the government to go get it from a court.
Absolutely, and I do believe that there should be a warrant requirement, so the notification would only be delayed in that event.
In this world we're now in, the full committee, as I said, I think I may have mentioned earlier, on the FISA reauthorization, we have said the same thing. If you're going to go search American citizens based on their phone number, their email address, in this haystack of information that's out there, if you're going to do that, go get a warrant. And we're having the same fight there. But it seems to me that getting a warrant, Fourth Amendment constitutional right, is how it has to be handled. My time has expired. I yield to the ranking member.